ذرا پلیز ٹھہر جائیے نا کہ امریکہ میں کیا ہوتا ہے، ولایت میں ہوتا ہے، آپ یہ کریں امریکہ ولایت میں جا کر کے پھر کیا ہوگا آپ کے ساتھ؟ ان دنیا میں ایسے ہوتا ہے یا صرف نظام عدل میں ایسا چلے گا؟ باقی دنیا کی ہم تاریخ میں بتاتے ہیں یہ دس از دا لاسٹ ڈے آف دا ہیئرنگ، پلیز ریمبر دیٹ. You can argue till 11:30. ٹھیک ہے، you are right, we are wrong. We have told everybody to file. ہاں بھی کاغذ کے ٹکڑے آ رہے ہیں بیچ میں سے، اور یہ کوئی آسان چیز ہے پڑھنا؟
اس لا ہے سر، اس میں
تو پہلے نہیں کر سکتے تھے فائل؟
لائن فرام دا ٹاپ.
دیکھیے وہ ذرا مناسب نہیں لگتا ہے. سپریم کورٹ آف پاکستان فل بینچ میں، سپریم کورٹ آف نیو جرسی کا ذرا ٹھہر تو جائیے نا. ہمیں ہمارا لیول اتنا نو تو نہ کر دیں. سپریم کورٹ آف امریکہ تو بتائیں، سپریم کورٹ آف نیو جرسی کو ہم فالو کریں گے.
میں صرف بتا رہا ہوں کہ
ہاں بتا دیں، زبانی بتا دیں. ہم آپ کی بات میں زیادہ وزن ہے بلکہ سپریم کورٹ آف نیو جرسی میں. The day we hear this case, the weeks we hear this case, our institution exceeds our disposal. The day we don't, our disposal exceeds our execution. If you think this is a never-ending hearing, this is the last day of the hearing.
My Lord.
Please remember that. You can argue till 11:30, and each one of us may have their views. Let them be expressed in judgments. I want to hear counsel.
Sir, when a question,
I mean, if you,
my Lord,
please continue. We will restrain ourselves. You just continue your argument so we can be enlightened what you want to tell us, and we can record it, and we can either agree with you or disagree with you in our judgments.
So, my Lord,
Please, next point. Please go on to the next. Please go on to the next point.
So my point is that, again, my Lord, that when the law is being given to the Parliament, hence subject to law, and for that I want to take you, my Lord, I have placed certain case law before Lordship, if my Lord has that.
دے دیے یا دیں گے؟
یہ رکھے ہوئے سر،
پہلے سے نہیں دیے
سر. دیے ہیں، بہت پہلے سے دیے ہوئے، رکھے ہوئے.
آج
نہیں سر، مطلب انہوں نے کہا جب آپ آرگیو کریں گے اس وقت دیجیے گا. میں تو ہر روز لے کے آ رہا ہوں سر.
سوری، دس از موسٹ انفیئر. ہم نے کہا تھا لوگوں کو فائل کر دیں.
یہ کیس
ہاں ٹھیک ہے، یو آر رائٹ، وی آر رانگ.
نہیں سر،
وی ہیو ٹولڈ ایوری بڈی ٹو فائل. ہاں بھی کاغذ کے ٹکڑے آ رہے ہیں بیچ میں سے، اور یہ کوئی آسان چیز ہے پڑھنا؟
اس لا ہے سر، اس میں
تو پہلے نہیں کر سکتے تھے فائل. ان دنیا میں ایسے ہوتا ہے یا صرف نظام عدل میں ایسا چلے گا؟ باقی دنیا کی ہم تاریخ میں بتاتے ہیں یہ. ذرا پلیز ٹھہر جائیے نا کہ امریکہ میں کیا ہوتا ہے، ولایت میں ہوتا ہے، آپ یہ کریں امریکہ ولایت میں جا کر کے پھر کیا ہوگا آپ کے ساتھ؟ وہاں تو آپ سارے ویسٹرن ٹریڈیشنز بتاتے ہیں، اسلامک ٹریڈیشنز تو بتاتے نہیں ہیں. اگر کاغذ کے معاملے میں ٹھیک ہے بھائی، میری مرضی جب میں کروں. سچ اے سینئر کاؤنسل.
My Lord, may I take page 144 of this? Is a case.
آپ ہمیں پروپوزیشن بتائیں، پہلے پروپوزیشن بتایا جاتا ہے.
How a subject to law has to be interpreted. That is my.
ٹھیک ہے، بتا دیں کیس کا نمبر.
Case is page 144 of this booklet, sir. Winberry versus Salisbury. It's a case from the American jurisdiction, and they have interpreted this word, what is the meaning of, and their constitution also provided this thing.
Their constitution also permits of documents in courts. چلے خیر. 144.
Sir, this is just a
یہ
case law.
سپریم کورٹ کا ہے، یہ سپریم کورٹ کا
نہیں sir, it is Supreme Court of New Jersey, sir.
اچھا ٹھیک ہے.
جی. My Lord, page 145, if my Lord kindly sees the sixth line from the top.
دیکھیے وہ ذرا مناسب نہیں لگتا ہے. سپریم کورٹ آف پاکستان فل بینچ میں، سپریم کورٹ آف نیو جرسی کا ذرا ٹھہر تو جائیے نا. ہمیں ہمارا لیول اتنا نو تو نہ کر دیں. سپریم کورٹ آف امریکہ تو بتائیں، سپریم کورٹ آف نیو جرسی کو ہم فالو کریں گے.
سر میں صرف بتا رہا ہوں کہ
ہاں بتا دیں، زبانی بتا دیں. ہم آپ کی بات میں زیادہ وزن ہے بلکہ سپریم کورٹ آف نیو جرسی میں.
ان کے کانسٹیٹیوشن میں اس طرح کا لفظ نہیں ہے، لیکن ان کے جو اسٹیٹس ہیں ان کے کانسٹیٹیوشن میں اس طرح کے لفظ ہیں. Kindly see, the Supreme Court shall make rules governing the administration of all courts, state, and subject to law the practice and procedure of all such courts. This is the law which they interpreted. And my Lord, it says, para 2 on page 145.
The phrase subject to law.
The phrase subject to law is not only ambiguous but elliptical. No word.
What is elliptical mean?
Sir, matlab ki it is confusing.
Ji. You're reading a word. You tell us the meaning of the word.
Continuous, sir. Continuous. No word in the law has more varied meaning than the term law itself. Nor is the phrase subject to crystal clear, for the phrase implies a limitation rather than a grant of power. It is argued by plaintiffs subject to subject to statute or legislation.
It is argued. ये judgment भी नहीं है.
जी आ रहा हूँ sir. If subject to, अब नीचे last paragraph sir. If the subject were to interpret it to mean subject to legislation, it would necessarily follow that once the legislature has passed a statute in conflict with the rule of court, the rule-making power of Supreme Court will become functus officio. For it would intolerable to hold, as has been suggested to us, that after the legislature have passed an act modifying a rule, the Supreme Court might in turn adopt a new rule overriding the statute, and so on ad nauseum. And yet, if subject to law means subject to legislation, any other construction of rule-making power would be in conflict with fundamental rule of constitutional constraint that unless the context clearly requires otherwise, a constitutional grant of authority is to be interpreted as a continuing power. My lord, then the last three lines, page 146. All these...
Page 147 से पढ़ लीजिए.
जी हाँ, उसमें आ रहा हूँ.
Page 147, last two lines से पढ़ लीजिए.
जी, बहुत बेहतर.
वो वही आ रहा है, नीचे आ रहा है.
जी, इसमें फिर सब पेज 146 पे
147 की लास्ट टू लाइन से पढ़ लीजिए ना, वो आपको थोड़ा सा उसमें जवाब मिल रहा है.
जवाब आ रहा है कि मैं कुछ आपको पॉइंट आउट करना चाह रहा हूँ कि पेज 146 के लास्ट तीन लाइंस देख लीजिए. मैं सिर्फ वो जो पॉइंट्स हैं उसको आपको दिखा दूंगा सर. It is conceivable that the people granted continuing power to the courts in all these respects or withheld it with reference to rule making, sir. Then, my lord, page 147.
Last two lines.
Okay. If the Raj may amend the rules or it may decide the extent to which the law division charge shall exercise the powers and functions of other division. It may control the degree to which legal and equitable relief may be granted in any court. We think it may be safely and that no such thoughts are ever in the mind of the member of Constitutional Convention or any citizen who voted for the Constitution. Yet, if subject to law means subject to legislation, such results might inevitably follow. The courts in some of their essential judicial operations, instead of being one of three coordinate branches of state government, would have been rendered subservient to the legislature in a fashion never contemplated by any. What then is the meaning of subject to law? The only interpretation of subject law that will not defeat the objective of the people to establish an integrated judicial system which is independent and which will at the same time give rational significance to phrase is to construe it as equivalent of substantive law as distinguished from pleading and practice. The distinction between substantive, which defines our rights and duties, and the law of pleading and practice, or through which such rights and duties are enforced in courts, is a fundamental one that is part of daily thinking of judges. Substantive law includes much more than legislation. It comprehends also the rights and duties which have come down to us through the common law. The phrase subject to law in Article 6 of the Constitution thus serves as a continuous reminder that rule-making power as to practice must not invade the field of substantive law as such. While the courts necessarily make new substantive law through the decision of specific case in communism, they are not to make substantive law wholesale through the exercise of rule-making power. That is the concept. So subject to law does not give power to legislate. It is not subject to legislation. Where it is made subject to legislation, then the Constitution uses the words. Make such, as pointed out. ये कई articles हैं of the Constitution, मैंने 154, 150, then 140,
Don't repeat.
240, 241 and 242 के अंदर भी यही लफ्ज हुआ है, make by
Mr.
law.
Abid, the law which is in dispute has been made pursuant to Article 175(2).
Yes, I'm coming
This
to
is the power of the
Sir,
judicature.
but utmost
So,
respect.
in the law itself, pursuant to Article 175(2),
Read
read with Article
Article
191.
191. Article
So we
191.
are making much time on 191. What about Article
I'm coming to that.
175(2)? Because
I'm
no
grateful to
court has jurisdiction unless conferred by the Constitution or the law.
Yes, but 175(2) cannot be read in isolation. That is
No,
the
no,
judgment of
it
this
is,
court.
it is the dedicated to the judicator.
Sir, may I please
So
submit?
power of the court are covered under Article 175.
Read with Article
Read
142.
with, that is the law that have made under pursuant to 190, read with 191.
Yes,
but
but
the
the-
law has been made pursuant to Article 175.
My lord,
उसको पढ़े ना 2 में आपके वो
जी, हाँ।
jurisdiction,
जी।
किसी कोर्ट का jurisdiction जो है, that is related and
तो
based
इसका
on
मतलब
the
फिर
premise of
जी, बिल्कुल आप
Article
सही कह रहे हैं।
175(2).
My lord, then provincial law भी आपके लिए
कोई भी
province
है,
बना
the
सकता है.
courts 175, there
Two.
shall be a Supreme Court of Pakistan, a High
जी.
Court for each province.
And such a
and
court
the
has
High
may be
Court for
established by
Islam.
law. In no court, number,
Article 2,
G,
no
no
court
court shall have any jurisdiction save as is or may be conferred on it by constitution by or under any law. That is synonymous. But humble submission is that this honorable court has interpreted when it deals with the Supreme Court, it has to be read with two further articles, Article 142A and Entry 55. May I take your lordship to Article 142A?
Yes.
And that is the judgment of this honorable court, sir.
So this article, I don't understand.
It's not a standalone article, sir.
It is?
does no. With humble submission, that is.
No, you are now reading words into the Constitution.
I'm reading-
No, where does it say it's not a standalone article?
It's because the judgment of the
So you
Supreme
can
Court says.
imply it, but it doesn't say so.
Sir, I'm not saying anything on my own. I based my arguments on case law and I cite a case law on that of this honorable what they have said.
I think the whole object of a full court hearing counsel is being missed. If all we are going to do is keep referring to case law, we are sitting, the full court is sitting, I don't even think you understand the gravity of it. To understand, to learn from counsel. Refer to this judgment, refer to that judgment. Bhai, the plain words of the Constitution, you don't want to read, then you want to read New Jersey Supreme Court, let's read plain words of the Constitution.
But
Let here counsel formulate submissions on that.
My humble-
Then by all means, if there is some ambiguity, we can
My
go
humble
to
submission-
precedent.
My humble submission
You see,
is that
the main rule for constitutional interpretation is that the entire constitution has to be
Read as a whole.
in a context. You cannot pick up one article and just read it in isolation because there are other articles which either may restrict or enhance that power
Yes.
which exists in
and
one
how that power is to be
particular
exercised. What is the law they are talking about in Article 7175(2)? No court conferred on it by constitution or by under any law. So the only two articles of the constitution when it concerns the honorable Supreme Court is Article.
ये बार Honorable Supreme Court नहीं होता है, Supreme Court Honorable
Supreme-
judges होते हैं.
जी, सर,
अंग्रेजी का तो सही इस्तेमाल कर लेना.
Sir, हम
Honorable
ये-
Parliament
हम-
नहीं
हम
कहते
ये
हैं.
भी आप ही करते हैं. हम यही करते हुए आ रहे हैं, सर.
चलिए आगे चले पॉइंट
जी,
बताएं ना आगे.
my humble submission is that
Mr. Zubairi-
Article 175(2)
जी ठीक
has
है,
to
हमने
be
पॉइंट
read
नोट
with
आपने कहा has to be read with
Article 142A and Entry 55.
142A and
And
entry
entry
55.
55.
Let's read 142A.
Mr. Zubairi, the point, it seems to me,